So the DOJ, AG Bondi, 25 states, and now multiple 2A organizations have joined to support the fight against statewide concealed carry ban laws. That challenge is now heading to Supreme Court conference. So let's break down what is happening in this critical concealed carry ban case. Now, before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. You guys know that 1st Phorm's an amazing company. They have great supplements. I use their protein powder, their pre-workout when I work out. They also have a ton of great apparel if you're interested in that type of thing. But one of the really cool things about 1st Phorm is they're pro-freedom, pro-America. They support the Second Amendment and what we do here on the channel. So I'd love for you guys to check out 1st Phorm. You can check them out using the link down below in the details section and also in the pinned comment. Again, they support us here on the channel and they support the 2A cause that we put forward here on these videos. So as I mentioned in the intro, in this video, I have some important updates for everyone in states like New York, California, Hawaii, and others who are currently facing attempts to ban concealed carry within those states. The Hawaii Wolford versus Lopez case is currently seeking emergency Supreme Court intervention. This challenge revolves around a preliminary injunction and the Ninth Circuit finding that the state can put in place catch-all public property bans, and that would be permissible under the Second Amendment. Recently, to the surprise of many, the DOJ and AG Bondi have stepped up in support of this challenge. They filed an amicus brief to the Supreme Court arguing that it's finally time for the Supreme Court to actually review these type of concealed carry ban cases, and they need to look at what lower courts and states are doing in response to Bruen. That's great news because you have the Trump DOJ actually pushing the Supreme Court to take on these critical concealed carry ban issues. That effort has now also been joined by 25 pro-2A states and then also multiple 2A organizations who are also pushing the Supreme Court to grant review to this critical challenge. Now, if you're not aware of what this challenge involves, this revolves around Hawaii's new laws on concealed carry that they passed in direct response to Bruen. This law, like others, tried to add more restrictions to the concealed carry laws there in the state and essentially create a default rule where individuals can carry firearms on private property only if the owner of that property provides express permission to do so at that location. Because of this, plaintiffs along with 2A organizations sued the state of Hawaii to strike down that new law. And on review, a district court issued a temporary restraining order, which was then later converted to a preliminary injunction. Now, in that ruling, the district court blocked the private property rule as likely a violation of the Second Amendment, and the court also found that it was inconsistent with Bruen. This case eventually made its way to the Ninth Circuit along with the California concealed carry ban, and on review, the Ninth Circuit upheld the catch-all property ban and reversed the injunction that was issued down below in the district court in Hawaii. The Ninth Circuit relied on older restrictions on hunting in private property to support that type of statewide concealed carry ban. Now, after that, the plaintiffs then asked for the Ninth Circuit to review that case en banc, but that was actually denied. Now, you did have some dissenting opinions from judges like Judge Van Dyke, who were joined by other judges on the Ninth Circuit who said essentially that their colleagues were not taking the Second Amendment serious, that they were treating it like a second-class right, and they will continue to do so unless the Supreme Court steps in. That has now led this case to seek emergency Supreme Court intervention. Now, this case has kind of a long road ahead of it. It's kind of a long shot because the Supreme Court recently has denied, review to a lot of emergency intervention cases. They have denied review of a lot of preliminary injunction cases. However, now you have the United States who has stepped in support of this challenge. In the recent amicus brief filed by the Trump administration, they state that the near complete ban is flatly inconsistent with Bruen and the long history underlying it. Bruen recognized that an ordinary, law-abiding citizen has a general right to publicly carry arms for self-defense. Now, one of the interesting things with this brief is that the Trump administration is actually pushing the Supreme Court to take this case even though it's still at an interlocutory posture and it is dealing only with a preliminary injunction. This is important because we have seen the Supreme Court generally avoid interlocutory 2A cases, but the Trump administration is telling the Supreme Court that they should take this case here and now. They point out that Hawaii in the Ninth Circuit argued that there was nothing else for the lower court to develop at the trial, and no further evidence was actually needed to resolve this case. Now, that's critical for what Hawaii is now arguing to the Supreme Court and what they will argue probably, after this, and what the Supreme Court will need to consider at conference. Ultimately, Hawaii kind of caught themselves in a trap based on what they argued in the Ninth Circuit and now what they are arguing to the Supreme Court. Hawaii responded, as most anti-gun states do in this case, by arguing that essentially the case is still too early for review and that there is no split in the circuit courts on this issue, and that this needs to go down to the lower court for a final merits determination and for more evidence to be developed. They also try to push back against the Trump administration stepping in to support this case, and they argue that essentially the United States is an uninvited guest. They filed an uninvited amicus brief, and the Supreme Court really should just ignore all of those arguments. Now, also interesting, again, they push for this case to be sent back down to the lower court, that the lower court needs to resolve this on the final merits and more evidence needs to be developed. And they argue that despite the fact that at the Ninth Circuit level, they stated very expressly to the Ninth Circuit that none of that needed to happen. This contradiction was pointed out recently in the brief filed by Mr. Wolford in support of his petition. In the brief, he argues that Hawaii states that this court should deny this petition because the record is undeveloped. That argument is irreconcilable with its concession in the lower court that no such further development was necessary. At oral argument in the Ninth Circuit, Circuit Court Judge Schroeder asked the counsel for Hawaii, "Can I ask you a question on the preliminary injunction point? What else is there left to decide? What else is there to be litigated in this case?" And counsel for Hawaii responded to that by saying that we think there isn't anything. We think at the end of the day, these are not Second Amendment violations. Mr. Wolford argues in this response that counsel's concession on this issue is a judicial admission which is binding and conclusive. That concession that there was nothing left to litigate was well taken. They also go on to point out that as Judge Van Dyke recognized, the panel's ruling turns the general right to carry recognized in Bruin into a right to carry on only streets and sidewalks. That result effectively eviscerates the general right to public carry arms for self-defense, and that Hawaii cannot reasonably deny that that is the fact. Now, in this response, they point out also how Hawaii is trying to argue that their own state history and tradition supports this type of catch-all carry ban, and that should essentially trump and override the nation's history and tradition at large, and essentially ignore what Bruin says, ignore 1791 in the Second Amendment, but only look at the state-specific laws, and that the state-specific laws in Hawaii should override the national history and tradition. They state that effectively, Hawaii is claiming that its tradition trumps the founding. That assertion is self-evidently frivolous. So here the plaintiffs are pointing out that Hawaii has already conceded legally in the Ninth Circuit, and for the purposes of this Supreme Court petition, that there is nothing further developed at the lower court level. Therefore, they cannot now argue to the Supreme Court during this petition that the court should punt this case for further review and further development. The Ninth Circuit relied on that concession made by Hawaii in the Ninth Circuit level to reach their decision, and now they cannot simply backtrack those statements to try to avoid this Supreme Court review. So with the help of the Trump administration, the state of Hawaii might have got themselves kind of caught in a trap. A lot of Hawaii's brief is focused on kicking the case for further development, but again, like I mentioned, Hawaii conceded that issue at the Ninth Circuit level. Now, this case is gaining a lot of momentum, and now it's set for conference during the Supreme Court's next term on September 29th, which is in early of the Supreme Court's next term. So hopefully we would get news really soon that the Supreme Court is potentially going to take this case. Again, this still deals with an interlocutory issue, deals with a preliminary injunction, but here you have the Trump DOJ, 25 states, multiple 2A organizations, saying that the Supreme Court needs to take this case. And then also you have this whole issue where the state of Hawaii conceded that they did not need to develop this at the lower court level. Instead, this could be resolved right here and now. So this is going to be interesting to see how this plays out. Again, a very critical concealed carry case that is pending from the Supreme Court and is going to head to Supreme Court conference at the beginning of the next term next month. So as we get more information, as this develops, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armscholar.com. Over there, we have the free legal guide that you guys can get. All you have to do is put in your email, and then we will send you over a free PDF. I will leave a link also to that down below in the details section in the pinned comment where you can get that. And again, just check out the website, armscholar.com, where we have a lot of other things available like channel merch and other things like that. So as always, thank you guys so much for all of your support. And don't forget, this nation was built by Armed Scholars, and this nation will be maintained by Armed Scholars.